ordered trinkets and jewelry online using human remains of loved ones.
You heard that right. You heard what you heard. She's a nurse's assistant. She did it for years. She finally got caught. New judge. Exclusive courtroom only to this channel. Hi guys, it's Kathy. Here we go.
All right, Mr. Palmer, Mr. Assistant DA Palmer, please outline the case for me.
Attorney Tripp Fitzner contacted Trey Burgamy with the Washington County Sheriff's Office asking him to investigate a possible scam operation here in Washington County. Our office had been contacted by potential victims some of whom are listed in the accusation, stating that they had ordered trinkets and jewelry online using human remains of loved ones through a website, and had basically lost contact and never got money refunded, or the human remains sent back to them, or product as they ordered. Investigator Burgamy then looked at the P.O. box that the items were sent to. That P.O. box was registered in the defendant's name, who owned property here in Washington County. A visit to the property revealed a large amount of human remains, such as ashes and breast milk and other items of that sort. And upon further investigation, there was, I don't know the exact number, but a large amount of people through the course since February of 2021 up until date of arrest that had submitted orders to the defendant.
From 2021, did you say?
Yes,
Right.
Judge. Had submitted orders to the defendant and never received a refund or product or any of the remains that they had mailed in for what they had ordered. Several of those are listed in the actual accusation. Our current tally, since we began prosecuting the defendant for this, our current tally is somewhere around 350 have come forward. I believe in August of 2024, there was a week-long provision that is in the accusation. There was a trustee at the jail who was caught smuggling in cigarettes through a mop bucket to the women's pod, and there were certain female inmates that were taking the cigarettes out and dispersing it amongst themselves. This defendant was identified as one of the female inmates that was taking cigarettes and also dispersing the cigarettes amongst other female inmates.
Yes, Your Honor. We're asking the court to accept these recommendations, in particular with first offender and 1613-2A in mind, as Ms. Magoon has no prior history. She has 2 children that she has supported and intends on supporting once she is released. 4 children, Your Honor. She has no criminal history, that being a misdemeanor or a felony. She is, or having known Ms. Magoon for the past few months, Your Honor, she is not the type of client that I believe this court is ever likely to see again.
So where are these 4 children now?
Those 4 children are with their biological father, Your Honor. Since her arrest, their father has been solely caring for the children, and that has been a factor in Ms. Magoon's strategy with this case, Your Honor, is that she has desperately desired to get out so she can, again, prepare to provide for her family and her children.
What is her age?
33.
She's 33, Your Honor.
And how old are the children?
4, 5, or 3, 4, 6, and 7.
3, 4, 6, and 7, Your Honor.
Now, Mr. Palmer, you had said that there was a victim who wished to make a statement.
Yes, ma'am.
All right, you may
I believe
present
it's
any
Ms. Weiss.
What now?
I believe it's Ms. Weiss,
Okay,
and she is appearing by WebEx.
all right, you may present that now. Carissa Weiss,
Ms. Weiss,
Yes,
hear us?
ma'am.
There we go.
there's Miss, can you hear us, Miss Weiss?
Yes, ma'am, I can. Can y'all hear me?
Yes, all right. I'm Judge Palmer. I'm not related to the prosecutor Palmer now. He's a nice guy, got the same last name as me, but we're not related. So tell me what it is you have to say about this case.
Well, my name is Krista Weiss, and I stand here for not only myself, but the many victims who placed their trust, their money, and their most precious belongings in the hands of Destiny McGoon. On June 6, 2022, I lost my fiance. In my grief, I trusted Ms. McGoon with some of the most precious and irreplaceable things I had left of him, his ashes, to create memorial keepsakes. What should have been a source of comfort was instead turned into years of distress, heartbreak, and financial loss. I was misled, ignored, blamed, and even harassed when I tried to get answers. Orders I paid for were not completed as promised. Pieces I did receive were defective. And instead of compassion, I was met with hostility, false accusations, and eventually being blocked on social media. The most devastating part is I don't know what truly happened to Sean's ashes. I was promised they would be handled respectfully and returned, but I was told contradictory things and left with nothing but doubt and grief all over again. The emotional toll has been enormous. Losing my fiance was already one of the hardest things I ever had to go through. Having his ashes mishandled and disrespected has been like losing him all over again. My trust was broken at the time when I was most vulnerable, and instead of peace, I was given pain and uncertainty. And unfortunately, I'm not alone. Other victims sent in the last of their breast milk, ashes of their lost children and babies, and other irreplaceable sentimental items. These are things that can never be replaced. Instead of compassion and respect, we were met with silence, excuses, and blame, and even hostility. We were re-traumatized at the most vulnerable times of our lives. The emotional damage cannot be measured. We trusted Ms. McGoon with the most sacred pieces of our lives, and she exploited that trust. The financial loss matters, but the true cost is the pain, betrayal, and uncertainty that every victim now carries forever. Your Honor, we ask that the court recognize the lasting harm her actions have caused and to hold her accountable so that no one else will ever have to endure what we've been through.
Thank you, Ms. Wise. We appreciate you appearing and speaking as a victim to this case. All right, any others you have, Mr. Palmer, who wish to present anything,
I don't
any
believe
written
so.
statements? Or all
I
right,
believe that's all from the state judge.
all right, thank you. Okay. Remind me, Ms. McGoon, what was that associate's degree in?
Associate's degree in allied health science, and I also got my LNA through medical school.
All right. Anything else you wish to add then, Mr. Boatwright, before the court announces sentence?
I would just like to restate my previous argument, Your Honor, that, again, I do believe she would be a good candidate for first offender and 1613-2. She has no criminal history in either misdemeanors or felony cases. It's her intention, once she is released from her incarceration, to re-enter the world and attempt to create or fix the situation that has led her to be where she is, Your Honor. And the designation as a felon would inhibit her ability to provide financially for her family and herself and her children. And we would ask the court again to just please sentence her under first offender in 1613-2.
Did I understand correctly, Mr. Assistant DA, that the prohibited item was cigarettes only?
It was.
Okay.
Yes, ma'am.
All right, please stand, Ms. McGoon. Ms. McGoon, the court does find that you have freely, voluntarily, understandingly, and knowingly entered a plea of guilty to 25 CR 76 and 25 CR 77. The court finds that there's a factual basis for the plea of guilty in each of the separate cases. The court, well, I have to ask you this. Has anyone, other than the sentencing agreement, has anyone offered you reward or leniency to get you to enter this plea?
No, Your Honor.
Has anyone forced or threatened you in any way to make you enter the plea?
No, Your Honor.
And you are guilty of each of the separate offenses.
Yes, Your Honor.
Then the court finds that you have not been offered reward or leniency to enter the plea, nor has anyone brought undue influence against you to force you to enter the plea. Your plea of guilty is accepted to 25 CR 76. Your plea of guilty is accepted to 25 CR 77.
I will play the full hearing on my live stream shortly. So this is just a summary. If you want to hear all of the details, watch my live.
On 25 CR 76, the court has considered your request for treatment under the First Offender Act. The court declines to grant that request. It's the judgment sentence of the court. On count 1, you're sentenced to 10 years of incarceration. Count 2, you're sentenced to 10 years of probation consecutive to count 1. On count 3, 10 years of probation consecutive to count 2. So it's a 30-year sentence, 10 to serve, followed by 20 on probation. No contact with any listed victim. You heard the statement of the one victim who appeared on behalf of herself and others and the trauma to which they've been exposed, so have no contact with them whatsoever. Sheriff, I didn't speak to you, but it is cigarettes, and I hate to pin 2 felonies on her. Do you mind if I give her 1613 too? All right, because this is the sheriff's doing. I mean, I understand the levity of it, but I also understand that maybe your association can now speak to the legislature if you're so inclined. There's always a remedy, isn't there? Okay. I'm inclined to give her that. I really do hate to pin a drug charge on her
Yes, Your Honor, thank you.
because, that can be even worse. And of course, it would give her the 2, which would enhance punishment later and that sort of thing. So if it had been something else, I might not have been inclined to do so, but since it's cigarettes, as bad as that is, it could be a lot worse if you want to. Of course, I know sin's sin, crime's crime, but nonetheless, I am recognizing what 2 felonies can do to one's
And we
record.
appreciate that. Thank you, Your Honor.
So I would grant that request.
Thank you.
So as to, and you have to consent to treatment under 1613-2 on the record. Do you consent to treatment under 1613-2?
Okay. Yes, Your Honor.
All right. It's the judgment sentence of the court to 25 CR 77. Count 1, 5 years to serve concurrent with all other sentences. On count 2, 5 years to serve concurrent with count 1 and all other sentences. So it's a 5-year sentence that you'll be serving at the same time as your other sentence. All right, do you understand?
Yes, Your Honor.
All right. That's the judgment sentence of the court. Mr. Boatwright, thank you for being present this afternoon so that we, whatever. What did? Escape, okay. You are being sentenced to serve time in the penitentiaries of the state of Georgia. If you escape, you'd be charged with a new offense of escape by a convicted felon. And the penalty for that is to require you to serve every day of your sentence, 30 years, followed by an additional 10 for the escape. And there could be an enhancement for that if you use any type of a weapon. So do not escape. That's the judgment sentence of the court. Thank you.
And I do have just one last thing, Your Honor. I know the state did mention it and the court put it on the record, but just so I say it for my own benefit, Ms. Magoon has been incarcerated here in the Washington County Jail for approximately 16 months. Is a part of the negotiated sentence that she get full credit for those 16 months towards the time that she
The
served.
statute would allow it anyway.
Thank you, Judge.
Yes, she's allowed that. It's allowed by law. All right. That's the judgment sentence of the court. Good luck. And Ms. Weiss and others, thank you for appearing.
And that's all I
like
have, Your Honor.
this.
If I may be excused.
Yes, sir. You can go. We should have done a shot every time he said I had to cut it out. I couldn't play it. Unfortunately, for my Vibers who are going to watch this on my live stream coming up, they're going to hear every I'm not cutting it. We watch the full thing. We don't cherry pick the parts that we want to see. This is court. We watch it all, the good, the bad, the ugly. So you only get to see judges like this on my channel. So watch my live stream, guys. It's way more fun than just the videos. Thanks for coming out. I really appreciate it. I'll see you all again soon. Bye.